I beg to mention one item, my lord. I filed it yesterday, my lord. Urgency is there, so may I please this item may come up tomorrow.
What is the urgency? What
But my lord, account has been freezed, my lord, since last 15 March.
it come day after Friday?
Friday will be late, my lord. May I Thursday?
Why?
Thursday, my lord. May I please?
15 March.
15 month, 1 month, my lord. 1 month going to expire, my lord.
That's right. Instead of tomorrow, have it day after, unless there is a personal difficulty on your part.
Then fine.
Have it on 11th?
11th is last working day, my lord. That's right.
Huh?
Last working day, my lord.
Last working. You want it tomorrow, all right? Tomorrow.
May I please, Lordship? Lordship, I want to withdraw one petition with regard to electricity.
Tomorrow?
If it's possible to at 2 p.m. Lordship, because the urgency is there, they are insisting that
You want it today?
Lordship, only for withdraw. Much.
I have the honor to mention on this petition matter. It is filed yesterday matter. Matter partition add of work matter.
Huh?
Contextual work matter. Add of work.
Award of war.
So matter they have already issued the LOA matter. So it's an urgent matter. Can it be taken day after tomorrow?
Friday.
Friday.
You want it on Thursday, all right?
Matter.
May I please, Lordship? My Lord, I pray for listing of the IA that this was a repetition for rectification in the particular in the order.
Tomorrow?
Tomorrow, my Lord. Outline.
May I please, Lordship? With the consent of the petitioner, counsel, I beg to make item number 31, Lordship. My Lord, personal difficulty is there. My Lord, matter may be adjourned for the day.
31.
My Lord.
So I am appealing for the petitioner.
31. You are making on behalf of the respondent.
My Lord.
31 at the request of the counsel.
Appealing for the petitioner. That's what date may be fixed.
You are Mr.
A. Ahmed.
A. Ahmed.
What date may be fixed.
Noted. After 3 weeks.
Much obliged.
May I please, Lord? Because I beg to mention item number 21, my lord, from daily list. I may be allowed to withdraw this retribution, my lord, as per instruction on
WPC 1962.
WPC 1962 of 2020.
Your name?
A. Ahmed.
Sir A. Ahmed. That the petitioner not wish to press the petition any further. Record. Petition may be taking into consideration the subject. Reported.
Mean PG Lordship. Lordship, I beg to mention item number 18 of today's daily list.
Yeah.
Lordship, we have taken consent from the other side. Some time will be required, Lordship, for us to obtain an instruction.
Item 18 at the request of Mr. M. Kuya, Council for Health.
This will be for PWD, Lordship.
PWD. Hence referred to be listed after.
Much obliged.
May I please, Your Lordship? Your Lordship, in respect of item number 38, Lordship, I'm seeking for a short accommodating, Lordship.
Lordship,
Item
I'm
number
appealing for
38, Lordship.
exponent number 1 to 5 in this matter. In item 38.
38.
38, Lordship.
Yes. You want time.
Yes, Lordship, to file our rejoinder affidavit, Lord.
Rejoinder affidavit.
Yes, Lordship.
Council for petition for 6 weeks time to file rejoinder affidavit. Prayer made objected to by the council to respondent.
1 to 5.
Any objections?
No.
Placed after 2 weeks.
Your Lordship, can it be on the first week of May, Lordship?
Or at least in the first week of May. On a date to be fixed by the date.
Highly obliged.
May it please your Lordship, with the consent of other side, I beg to mention item number 24, Lordship. In this matter, we have to file our objection, Lordship. Kindly grant us 2 weeks of time, Lordship.
Item 24, council for the respondent, praise for 2 weeks time to file objection. Who's for the petitioner?
Lordship, we have taken consent PK Gairo.
Submitted that consent, the council taken. It's accordingly after 3 weeks.
Obliged, Lordship. May I please your Lordship? Lordship, I beg to mention item number 1, Lordship.
Yes.
Let this matter fixed after PK.
You wait until the matter is called up with item 1.
Lordship.
You wait.
May I please your Lordship? Lordship, I beg to mention item 31, 32 and 33 of the daily list. My senior has some personal difficulty. This matter may be taken up after Bihu, your Lordship.
32.
32 and 33.
You are making a mention on whose behalf?
HK Das for the petitioner.
32 and 33 at the request made by, on behalf of the petitioner, matters have referred. It is listed after 4 weeks.
Deeply obliged.
May I please, Lordship, with the consent of the other side, I beg to mention item number 14. My senior
1
counsel,
4.
1-4. My senior counsel are Islam out of ST.
Mention is made on behalf of Mr. R. Islam. That the matter be adjourned. Prayer is not objected by.
Wait, please, your Lordship. My Lordship, with the consent of the petitioners, I beg to mention item number 27. My Lords, we were supposed to, I'm from the Fishery Department. We're supposed to file an affidavit. My Lords may grant us 2 more weeks.
Yes, 27, any objection?
No, Lordship.
27, the request made by the council for the fishery department. But
Obliged.
Lordship, I beg to mention item number 29. My lord, the opposite side has filed affidavit in opposition yesterday, ma'am. So hence the record may kindly be called from the
Hmm?
The record may kindly be
you are
called.
appearing on whose behalf?
N Saikya, madam, from the petition.
For the petitioner.
Yes.
Who has filed the affidavit?
N Saikya, Nirupama.
You have filed the affidavit.
No, yes, ma'am. No, the other party, affidavit in opposition, they filed it yesterday.
They filed it yesterday. Let them make a mention. Why are you making mention?
I thought to call for the record from
The record will come as and when the matter is called up. You make it.
May I please, your Lordship, I beg to mention item number 40 of daily list. Respondent, last week, respondent filed their affidavit in opposition. We need some time to file our reply.
Item 40.
40.
At the request of council, petitioner matters have referred listed up. Enabling the petitioner to file reply. Mr. A. Bhupan for
The GAD, man. We have filed our affidavit.
Yes.
May I please, your Lordship? Your Lordship, I beg to mention one late petition for listing tomorrow, your Lordship, for withdrawal.
For withdrawal.
Yes, sir. Hello.
Yes. You want adjournment.
Yes, Lord.
Council for petitioner, raise for adjournment. Matter be listed after 2 weeks.
Yeah.
The MCT, I guess, for the order.
May please, your Lordship. Item number 2 and 3, Lordship. Both this matter has become infractuous, Lordship. Lordship, may kindly allow me to withdraw it.
Mr. M. Ahmed.
Yes, Lordship.
Council for the petitioner have become infractuous because of threats of the the MS and Nora DNRD department of Mr. M. Sikir petition dismissed as not read. On withdrawal.
Yes, sir.
You want to withdraw it?
Yes.
Not withdraw. Noted many stand indicated item 2 and 3.
2 and 3.
You want liberty?
Yes, sir.
Take liberty.
High level.
So this contempt case has been filed for
Where is the order?
Lordship. Order is at page 12.
Hey,
Page 12.
operative part 13.
Operative part is at page 13. Where it, Lordship?
Amount has not been paid.
Not been paid till then.
And it's not been part. Alleging willful disobedience of the director contained in the order dated 27/2024 passed in the 5 of 2020. This contempt petition has been filed. It's depth of response by discussing future puts this stuff.
Deeply ordered.
May I please, Your Lordship? Lordship, the present contempt petition has been filed for violation of the order, which is at page number 9, Your Lordship. effective portion is at page number 11, the last paragraph.
And third, after alleging that the I or passing the by the but it was a notice by sole respondent.
Yes, sir.
Sole respondent by as well as extended after.
Obliged.
Please, Your Lordship. I'm appearing on behalf of Vigo's Lordship. Lordship, tenure is out of
What has happened to the settlement?
My lord, the settlement they are talking about is not with the Indian Oil Corporation. That is against the, my lord, in respect of the legal heirs of the original dealer. So far as the Indian Oil Corporation is concerned, my lord, we have asked them to give a reconstitution proposal because the person has died, and that, my lord, they have not been able
It's
to
a partnership.
My lord,
It is a partnership.
yes, my lord.
They want an adjournment.
No objection there. On
They
twice earlier, my lord, they have taken that.
The request of the council, Mr. I. Chakma, a hearing of the petitioner. Matters then referred to be listed after the third package of it by third
Go high, my lord.
all the response.
My lord,
1, 2, 3, 4.
2, 3, and 4, my lord.
2 for 1.
Union of India, my lord, I don't know who is appearing.
Union of
And there is a
2,
private
3 and
response.
Notice has not been issued. Notice has not been issued.
Notice has not been issued.
After 3 weeks.
Seven, 8, 11, 12, and 13. These are of the similar nature and similar cases, my lord. Last time, my learned friend was asked to get the instruction, but why it is not paid?
Lordship, item number 7, I have not received anything, but item number 8, I have received instruction, Your Lordship. As per my instruction, we have forwarded the bill to the Deputy Commissioner, Your Lordship, because we are only the executing, Your Lordship.
Yes, Deputy Commissioner.
We have not explained that.
Get your instruction there. 2 weeks. 2 weeks.
All these cases.
Mr. J5. Yes, to the petitioner. Water resources.
Yes, Your Lordship.
Submits that they have forwarded what?
I have forwarded that, we have forwarded the bill to the Deputy Commissioner in the year 2000.
After verification.
Lordship, yes, after verification, Your Lordship.
After verification of the claim made of, by the petition, he keeps the bit forwarded to the Deputy Commissioner. Not looking for.
Yes, Your Lordship.
Appearing for the Deputy Commissioner, speaks liberty of the court, completely instructed. The report each time. Prayer made is not taken. This recording after weeks. How many matters?
7, 8, 11, 12, and 13.
Others, Lordship, I have not
7,
received
8,
anything.
11,
12, and 13.
12 and 13.
My lord, he got the instruction only in item number 8.
Yes, Your Lordship.
Item 8.
Only item number 8. Others, I have also not received.
Item 8. Respect of 7, 11, 12, and 13. You're right. Council for the response. Report part at night.
Obliged.
My lord, non-payment of bill, my lord, against the hired vehicle by the Commissioner of Police.
Where is your work order?
Yes, my lord. FOC has already been issued, my lord. In item number 9, I have received instruction, my lord.
What remains?
Item number 9, 10 lakhs 32,000 and 10 12 lakh. We may take instruction, my lord, he may have got the.
Have you received the amount?
No, my lord. They call me us, but not given the money.
This is for one matter or both the matter?
It is for one matter, my lord. Item number 9.
9.
In 10, we have not received any.
Only my lord, petitioner is a case present and he is undergoing treatment at Apollo Hospital. Kindly consider that.
No, the
Already
financial
FOC
sanction has been issued.
Yes,
You are just required to receive it. Heard counted for the party. First claim made by the rate of 1166 of 25. Counsel to the government advocate has been to the court. The financial sanction amounting to 10 issued in respect of the writ. In the same communication, stated that the amount to be paid to the petition after fixation of CD in bracket efforts against the state sector. In that view of the matter, the matter said deferred to be listed after briefing, and the respondent will advise the court as to whether the FOC has been FOC has been received by the respondent authority for release of payment has been sanctioned. So far as item number 10 is concerned,
we have yet to receive any instruction, my lord.
whether
We
it's
allow
lying
the
straightforward by the government advocate for completion of instruction, it is settled again after 3.
I think that
Public. But it is connected.
I think you can kindly pass over the matter for timing.
It is passed over for the day.
Timing.
Time being.
my lord, in this matter, we have not yet received any instruction, my lord.
Notice has not been issued. The matter. How much time do you require?
Yeah, okay.
Have you sought for instruction?
No, my lord, earlier, my lord, it was listed to be appropriate instruction.
Let him, you get your instructions
Yes, yes.
after 2 weeks.
Yes, my lord.
All right. Item
15 minutes.
15, government advocate will obtain matter be listed after. Yeah.
The transport subsidy claims of the petitioner
Is it
were
covered?
dismissed on the ground that some important documents of the in respect of the same was not furnished by petitioner. The petitioner filed a petition before this honorable court, and this honorable court, my lord, by judgment at page 135.
Yeah.
And the relevant part at page my lord, 145. Paragraph 19, my lord. Here, my lord, from the minutes of the so-and-so meeting of the state level committee, it has emerged that the cause for the claims of the so-and-so authority were in respect of the apportionment periods, respect periods were received at the office of the general manager and Guwahati within a period of so-and-so, and from the last date of the previous quarter. The state level committee has, however, observed that at the submission of the so-and-so demands and clarification from the certain quarters, the claims of the transport subsidy of the petitioner could not be placed before the state level committee within the time specified of the 2 years from the date of the so-and-so condition. It was after assigning the region, the state level committee advised the member secretary to take up the matter with the Department of Industry Policy, Ministry of so-and-so. It was after the lapse of about 5 years, the Commissioner of Industry Commerce from the file dated so-and-so, they provided the matter to Director of Industry and Policy Promotion, Department of Industry, Community Media for consideration of the alleged time-barred claims of the petitioner company, along with 5 other alleged time-barred claims. While forwarding the proposal of the conciliation, the Department of Industries, the Commissioner of Industries and Commerce observed that the claims become time-barred for non-receipt of various important documents from the units in time, which ground was also found mentioned in the minutes so. Thereafter, page paragraph 20, my lord. From the objection made in the minutes of the meeting dated so-and-so, held on so-and-so, and the contents of the letter dated so-and-so, the Commission of Industry and Commerce, the issue that requires consideration is whether there was any base left on the part of the petitioner company in submitting the claims of the transport subsidy under the transport subsidy scheme before the respondent authority. The minutes of the so-and-so committee also observed that the original claims were submitted by the industry company within specific time at the office of the so-and-so. The region assigned to the minutes of the state level committee for the processing or not processing the claims the committee was for non-submission of certain important documents and clarification on certain matters. In the letter also it was mentioned that the claim for transport subsidy could not be placed before the state level committee in time due to delay in processing the claims of the state level committee as well as the commission level committee on the non-receipt of various important documents from the units in time. The letter of the commissioner is so and so. Thereafter, the finally below at page 149, 148. Paragraph 23. From the facts and circumstances placed in hand, it has become evident that there was no delay on the part of the petition company in submission of the quarterly claim for the transport subsidy for 5 years, different quarters, as indicated above. The delay which has occurred was clearly attributable to the office of the DIC Kamru and the office of the Commissioner of Industry and so-and-so, respectively, in processing such claims, and thereafter to forward the same to the next higher authority involved in the process of the claims, that is, state level committee. The delay that had occurred at the levels had ultimately resulted in the delayed placement before the state level committee, which was the final authority to examine the claim and to recommend disbursement if any claims were otherwise eligible for the grant of transport subsidy and the transport subsidy scheme. In such view of the matter, the region assigned in place in the minus of so-and-so and the letter of the so-and-so letter is found to be irrational and specious, and assigning such a irrational and specious person, the authority has sought to shift the fault to the producer company, which is found unreasonable, sustainable after perusal of the so-and-so. Ultimately, the directions which were issued, Lordship, at page 150, 7 or 8 lines from the bottom below. In such circumstances, in such view of the matter, as you also got him.
Paragraph 25.
Paragraph 25, last 8 or lines from the bottom below. In such view of the matter,
yes,
this court is of the view that the claims of the petitioner of the transport subsidy under so of the apportionment period deserve consideration at the end of the respondent authority Accordingly, the petition is disposed of directing the respondent authority, more particularly the so-and-so, to process the claims to be strictly on merits in terms of the provisions contained in so-and-so. So, my lord, the court said, my lord, that there was no delay and the delay was attributable to the respondent and thereby directed the respondent authority to process the claims strictly in merits. Now, my lord, after the judgment and order of this honorable court, the respondent authority again have passed the same order at page 158, 152, and at page 160, 56, you'll also find para 9.
One.
Again, my lord, citing the same reasons which was set aside by this honorable court, that there was a delay. Whereas this honorable court directed that the case should be heard, should be considered strictly in merits. Without considering merits, again the same thing has been reiterated. In fact, flouting the order of this honorable court and the directions without considering directions, they have passed a simple order.
There is a clear finding that there was no delay.
My lord. And the direction was to consider the claims strictly on merits. Now, again, the authorities have passed the order again on the same ground, whatever was assigned earlier, which was in the challenge before in the first expedition. In fact, this case, there is a lot of notice, your office may also initiate the sumo to contempt proceeding against the respondent authorities. Why they are flouting the order of this honorable court?
Yes.
Sometimes even to take instruction ballot, I have to go through them.
So instructions you take, but prima facie it appears that there is a clear direction by a coordinate bench that you have to decide the merit on issue of afresh on merits. And you are going back by saying that the claims have become time barred because certain documents could not be placed by the petitioner.
Ballot, meta may be fixed on immediately after vacation. Well, I'll go through it, ballot, all this direction and all coordinate bench, ballot.
Yes, Dr. Tara.
Thank you, Lordship.
Immediately after.
But in fact, my lord,
We are not issuing notice at this stage.
Yes, ballot.
Mr. Kolita,
Kolita is from the state, my lord, so
I'm from the state, Lordship.
Unless until some observations are there before Lordship, the instructions will not do, my lord. Instructions must come on the specific issue which is.
it's heard Dr. Rekha Saraf, a counsel invested by Mr. Peter. And it's heard the guy for
Respond number 1.
what?
1 and 6.
6.
1 and 6.
And Mr. Rekha,
2, 3, and 4, Lordship.
who's for 5?
It's Mr. Aziz Bhatta.
That fee is only my lord disbursing agency. We will serve a copy of it.
Yes, 5. The petitioner is for this court. The order. Take it. First of August, 2024, passed by Joint Secretary, Government of India, Ministry of Commerce and Industry, Department for Promotion of Industry and Internal Trade. By the impugned order, the claims for transport subsidy by the refrigerator quarters mentioned in the order have been rejected on the ground that some important documents of clarification on certain matters were not submitted, and as such the claims of the petitioner in respect of transport subsidy could not be placed before the state level committee within the specified time from the date of incurring the expense of the impugned order. Stated that the decision of rejection of the claim of the petitioner by the state level committee was found to be in order in accordance with the provisions of the scheme and instructions issued from time to time. That this order was issued by the authorities concerned pursuant to a directive of this court passed in WPC number 329 of 2014 and by judgment and order dated 29/8/20. By uh, the petitioner had approached this court earlier, challenging the rejection of its transport subsidy claim by the concerned authority. Upon hearing the matter in entirety, the court disposed of the writ petition, directing the respondent authority to process the claim of the petitioner strictly on merits in terms of the provisions contained in transport subsidy scheme of 1971. So, the relevant paragraph is instructed in para 25, 150. The perusal of the order passed, perusal of the judgment and order, paragraph of which is instructed above by the judgment and order dated to the past in it is clear the coordinate bench specifically directed for reconsideration of the transport subsidy claim, the writ petition by the respondent authority. This claim was directed to be made by the respondent authority strictly on merits in terms of the provision contained in the transport subsidy scheme 1975. The courted bench arrived at a finding that there was no delay which could have been attributed to the petitioner, and the genuine claim of the petitioner for transport subsidy under the transport subsidy scheme 1975 should not be rejected for a reason is not attributable to the applicant in bracket present. So,
Para 23.
in view of the specific directive, it's clear, specific directive that the court had made, it's clear that the respondent authority were required to reconsider the transport subsidy claim on merits in terms of transport subsidy scheme 1955. However, the perusal of the impugned order revealed that the claims of the petitioner appear to have been rejected on the ground that certain documents could not be submitted by the petitioner and which could not be and consequently the case of the petition could not be placed before the state level committee with its time limit. So, this aspect of the matter was well considered by court and bench earlier judge and ordered it. Under such circumstances, prima facie it clear that right that there is also no dispute that the judgment and order dated passed in that was not under review, nor has the DFE been filed with the respondent. After such circumstances, it appears that the authority concerned have disposed of or rejected the claim of in contravention with the direction contained in the judgment and order dated passed in the prima facie this court of the view that such action may expose the respondent to contumacious action. Since the rejection of the petitioner would not have been made on the ground of delay in the face of in view of the findings recorded by judgment and order dated when passed in the. However, the prayers made by the counsel for the respondents, liberty granted the respondents to complete their instructions in the matter and apprise the court as to why consequential orders, if required, may not be issued against the respondent for disregarding the direction contained in the order dated when passed in the. At this point, the court is not inclined to issue a notice. However, the respondents are permitted to complete their instructions in the matter and apprise the court as directed accordingly. Let the matter be listed the beginning from 28 on 30th of April.
30th of April, I have come. First week of May sometime.
5th of May. 5th of May.
Although Mr. Kalita, he has not taken instructions also, he is.
No, I don't have
He has no role.
My
But
role
the,
is gone.
but the direction of the court is to the respondents 2, 3, and 4. That's what we found. The earlier.
In the state level committee,
No,
but the
that was there in the state level committee. Later on, the direction was given
all right.
because we have sought from.
Although notices have not been issued in order to enable the respondent counsels with their instructions, sufficient extra copies be furnished within a period of 1 week. It's recorded.
I'm a place.
Please, Lordship. Please, Lordship.
Yes.
Lordship, the Lanka Municipality Board invites some tenders and for supply of sand cables, my lord. And once October today has submit his tender for cutting of rupees 925 per cubic meter sand cable, but unfortunately it was given one submit order at the higher rate of 1,250 rupees, my lord.
Who called for the tender? Who will call for the tender?
Lanka Municipality Board, my lord.
Lanka Municipality.
My lord.
Which one for Lanka Municipality? Yes. Executive officer, you can appear. Why? Executive officer is a government officer.
Yes, my lord.
You get instructions here.
But they appear for the my lord, whole municipality. They appear.
Who?
Municipal board, my lord. I can take instruction.
All right.
my lord.
Heard Senate Council for Party issued notice written and put Mr. M. Setia appears on behalf of Component 1,
1, 2, 3, and my lord.
3, 5.
Yes.
Council, Standing Council for Harbi Anglok appears for respondent number 6. and 8 to 11. Who's for 7? Mr. Gogoi. For 7.
Chief Conservator for
If 8 and 9 you can appear, 7 also you can appear. Alright, then 7, 8, 9, 10, 11. By Standing Council RBN. Now, he should notice return of copy in the respective council. Because the way that the copy is but one week. Steps, however, not responded occurred. 4 and 12 taken by registered proceedings within 1 week. Have been treated after the copy.
My lord, is a matter for this is a tender matter, my lord, for IMFL shop. Yeah, made for it. The tender was issued on 12/1/24. We had
Some
applied.
affidavit is filed.
Affidavit is filed.
Are you willing to file a reply or
No, my lord.
no reply?
because of some complaints we received, my lord. We scrutinized those complaints, my lord. We found nothing, my lord. There's a baseless complaint.
Okay, now
If Lordship accepts, my lord, we'll end, take it to logical conclusion and open the tender, my lord.
you were already settled with the shop. He was already
No. We floated a tender. He participated. He deposited his EMD, my lords. Then technical.
Technical bid, no bid was open, my lord.
That
No
bid was
technical, financial, nothing was open.
Okay, then
it was told, my lord. He came before the court, and my lord, we took instructions because of some kind of complaints, my lord, were received. Various complaints, my lord.
Page 34 onwards, my lord.
We
affidavit.
stalled the tender, my lords. Then we undertook some inquiry exercises, my lord, joint inquiry with the circle officer, with the excise inspector, my lord. Found all those complaints to be baseless, my lord. Then now, my lords, now we are going to open, my lord.
Yes.
Yes, my lord, if they open the, that is one of my prayers, my lord, if a petition. To proceed with the tender process. Since I have already deposited my earnest money deposit, I continue with the tender process. We have already.
If you don't open or continue, you refund it and earnest money.
No, my lord, if the honorable court may kindly direct, then tender process may start, my lord, because we have been kept in a limbo since more than 1 year. So, my lord, already I have paid rupees 5 lakhs as the earnest money deposit. Now, if they start the tender process, it will be beneficial for us.
Heard learned counsel filed by the petitioner seeking a direction to the responsible authorities proceed with the tender process. It was initiated by the capital E hyphen AID bid. Notice dated 12/1/2024, initiated by the Superintendent of Excise Unit of Business. The petitioner, the petitioner is not the intending tenderer and had submitted his bid along with earnest money deposit with tune of rupees 5 lakh.
5 lakh.
So, however, in spite of all the bids being submitted, the respondent authority did not proceed for settlement of bid tender. No information was forthcoming from the respondent as to when the bid process will be initiated. So, being agreed, we applied the present resolution. So, the respondents, although notice was not issued in the matter, respondent had filed an affidavit where there is a permit that the bid process was stalled because of certain complaints we received. By the respondent authority. After separate inquiries were made by the respondent authority. These complaints have been found to be based. And most of the applications, including the petitioner's application, are found to be in compliance of the prevailing norms for granting IMFL or applying. Whereas, in view of such averment being made by the respondent of 3, the affidavit type, there is no further reason expressed by the respondent warranting not warranting no further reason expressed by the respondent authority which reveal any hurdle for settlement of the debtor. The such circumstance, in view of the averment made, the is closed, permitting the respondent authority to proceed for settlement of the debtor, subject to adherence to the procedure prescribed by law, including the rules for settlement. Petition closed of the above directive. Given
Small observation, directing them to do it in an expeditious manner. If it pleases my lord, because it's been more than
Directing them
1 year.
to?
My lord, if it pleases the honorable court, directing the respondent authorities to expeditiously start, because it's been more than 1 year. Only if it pleases. That small observation.
the respondent will complete the tender process within a period of 90 days, the date of receipt of the certificate. Failing which, the petitioner and other pending tenders shall be refunded their
Deeply obliged.
None appears for the petitioner. This again after 1 day.
20.
You were there.
I'm there.
Mr. Renupadhyay. Hearing.
No.
You want us to close the matter?
Okay. After we got, after we got. Obliged.
May please the lord. And here, my lord, petitioner's trade license was cancelled, my lord. Against that, an appeal was preferred, my lord. Now the appeal has been pending, my lord. It has not been decided, my lord.
Appeal not decided.
Not decided, my lord.
Yes, get your instruction there.
Well, this,
Tinsica municipal board, madam. This notice may be.
my lord, appeal is pending before deputy commissioner, my lord. Respondent number 3, district commissioner, my lord.
You get your instruction.
Yes, madam.
Deputy Commissioner, day after tomorrow. Give me an extra copy, find out what is the status of the appeal. That's all. Matter be listed on Friday, on Thursday. Enabling the government advocate, Mr. MC, status of the appeal preferred by the regulation. Stated to be pending before the Deputy Commissioner.
My lord, respondent number 3.
Deputy Commissioner Tinsukia. Appeal against what?
Against, my lord, cancellation of trade license, my lord.
Cancellation of trade license. It submitted that the appeal was filed on which date?
On 22/7/24, my lord.
22/7.
2024. Para 8, I have stated, my lord.
27.
2024, my lord.
24. As stated in paragraph 7 of the paragraph 8 of the written.
Intake, my lord.
However,
In
same stated to have not been disposed of by the technical.
In the annexa, my lord, no date has been mentioned.
What's it?
You find out.
I have given
Is
the appeal number also, my lord.
Is the matter on Thursday?
Deeply
Get
obliged, my
your
lord.
My lord.
Yes.
My lord, we are before my lord for rejecting a tender technical bid. This is a tender relating to bid for IMFL retail off license shop in the 30th subdivision of Tinsukia district. I had bid 45 lakhs for this license, my lord, and my technical bid was rejected only on the ground. My lord, the rejection is at annexure
170.
page 173, my lord.
One 173.
One.
Yes. 173 is some.
I'm sorry, 171, my lord. And the relevant portion is at 172.
Your name is it?
I'm
Serial number 2.
At serial number 2.
Yes.
Well, the ground of rejection in my technical bid was that I have not submitted my site plan, which has been signed by an engineer. Now, my lord, Rule 51, or neither NIT nor Rule 51, envisages that I have to submit the plan proposal signed by the engineer. I have submitted the plan proposal of the site submitted by an architect, duly competent architect, which has been sealed, and he's a government approved architect, and it has been sealed and signed by him. But in Rule 51 of the Assam Excise Rules 2016, my lord, can
Yes, Rule 51.
51, my Rule 51. My lord, you find at page 28.
Yes.
Application for grant of a compounding, blending, reducing, and bottling license. At 51, subsection 1, subrule 1, a description of the site and plan of the building in triplicate in which the manufacturing operations is proposed to be established by the applicant, specifying the number, size, and description of the plant and apparatus proposed to be installed therein. Nowhere here it says that it has to be signed by an engineer. There's no requirement. And they've arbitrarily rejected my bid on just on this ground. My lord, they have allotted to the blue-eyed license to the blue-eyed boy, that is respondent number 6. He has bid 10 lakhs. I have bid 45 lakhs.
Who is the respondent?
Respondent 6, my lord.
Name in page 171.
Yes, my lord.
Yes. MDP services.
MDP services at 1.
Okay.
That's serial number 1. Now, number 1, my lord, our main contention is that he has not submitted the full bid document, that is Annexure C. Annexure C is mandatory. The winning bidder has not submitted Annexure C in the bid document while filing his NIT matter. In another case, in allotment in a tender relating to Kamrup district, my issue is in Tinsukia district. Another bidder's bid was rejected, my lord, only solely on the ground that there's no Annexure C.
What is Annexure C?
Annexure C is a compilation of all the documents that has been filed with the NIT, my lord.
That is mandatory.
Is it prescribed in the NIT?
My lord, NHSC is, my lord, may kindly come to page 364. 364, one Lilima Saika Borua, the same man, it is relating to Kamrup district. Duly filled annexure C is not submitted. That is why her bid has been rejected.
No. Where does one find annexure C? Is it a part of the bid or the part of the rules?
It is a part of the bid, my lord.
Is it available here?
Yes. I'll just complete.
Case 50. Case 50. Annexure C.
Page number?
The annexure C.
We just wanted to see what is annexure C.
Case 50. Look.
Page number?
50.
15.
50.
50.
What is annexure C? Checklist.
Checklist. So that has not been filed and signed by the winning bidder, my lord. That is mandatory requirement. In other cases,
but nevertheless, your case is rejected because it is not signed by an engineer.
Yes. By an engineer.
Whereas the architect has
Duly signed and certified. And that is not the requirement under the Assam Excise Rules 2016, neither in the bid document.
Yes.
So can you see the page 53?
53.
Yes.
Yeah.
Column 12 lawsuit down below lawsuit. Site information. Site plan certified by an engineer. That is one of the tender condition laws.
So engineer means?
Civil engineer.
What is the difference between a civil engineer and an architect?
Architectural lawsuit, he made the drawing lawsuit.
It is already signed by an architect.
Lawsuit.
He is also a technical person.
No.
And you have not specified civil engineer.
No.
It's your
in
interpretation.
site laws, in generally site in the house or buildings, that is generally doing by the civil engineer. How far is that?
No. May not be a correct interpretation.
My submission will be recorded.
Your governor.
Standing council exercise. 1 to 5 lakhs.
1, 4, 5.
Lakhs.
Mr. Puru also.
No.
You are not appearing. Yes, the petitioner is agreed by the rejection of her bid on the ground. Where is the rejection?
My lord, annexure 3.
Page number?
171.
Is agreed by the rejection of a bid by the scrutiny committee in connection with the grant of fresh IMFL within quotes of quotes closed shops in the Tinsukia district. The petitioner was one of the intending bidders to the bid invited by the respondent for settlement of IMFL off. It's a shop.
Yes, Malad.
IMFL off shop.
Yes.
Off shop.
The district of Miscellaneous. Subset a perusal of the minutes reflect that the bid of the petitioner was rejected on the ground that the site plan submitted by the petitioner is not certified by the engineer. That quote, site plan submitted is not certified by the engineer. Right. Quotes. So, the private respondent number 6 was the shortlisted candidate. So it is further submitted that the petitioner's bids were rejected notwithstanding she being the highest bidder as per information available. So, the petitioner had offered a bid of
45 lakh.
45 lakh as
Approximate.
opposed to the bid of the respondent number 6,
10 lakh.
uh, uh, as opposed to the bid of rupees 10 lakhs offered by the respondent number 6. So, it is the further submission that the Annexure C as mandated in the bid document was not submitted by the respondent number 6. Therefore, the bid paper of the respondent number 6 was incomplete and therefore could not have been considered a valid responsive bidder. So, the internal senior officer referred to Annexure 5, page 173 of the railway petition, which is the drawing of the proposed site for the shop where the petitioner had intended to open the IMFL Court shop in the event of being the shortlisted candidate. So, the senior officer submits by referring to the drawing that it is duly signed by the concerned architect who had prepared the drawing. So, therefore, the ground for rejection of the petition that it is not signed by an engineer is not tenable ground. So, it is further submitted that the groups, some excise groups, if one does not prescribe for submission of the site plan signed by the engineer. So, under such circumstances, the rejection of the petitioner bid and the shortlisting of the respondent number 6 council hearing standing council for the excise department. However, submits that a bid document itself is 53 contains the clause that the drawings are required to be site plan must be certified by. In that view of the matter, there was no infirmity in the screening committee rejecting the bid of the petition as the same was not certified by the requirements of the bidding process. So, considering the dispute raised between the parties as to whether the certification issued by the concerned architect would be sufficient to be accepted as certification issued by the engineer as prescribed under the bid document. At this stage, court considers it necessary to push the motions whether late motion should be done or wait. Since the excise department represented by Leonard Stanton waived our extra copy, but had to be listed after the returnable date. What is the stage of the?
My lord, the last space lot, already allotment was given.
Allotment is given, my lord, but my lord,
360, last space lot. Last space, 366.
Has it been operated?
No, my lord. That is,
my lord, just protect me, my lord, the status quo order maybe. Interim maybe.
The counsel for the petitioner has been able to make out the case praying for interim order. But the drawing submitted by the rectification party certified by architect who is where the drawing of site plan. Drawing/site plan. So, no materials have been placed by the respondent authority by referring to any provision of the show that certification by the concerned architect will not suffice the requirement of certification by engineer within books as provided in the head document. Under such circumstances, the work order has not been.
No, my lord. Work order has not.
that instruction I don't have.
Letter of acceptance issued in favor of the private respondent shall remain state the next date of its date.
But if not issued lot, I don't know whether LOA has
If
been
not issued, if issued.
If issued lot. If issued lot. Yeah.
Letter of acceptance shall remain state the next date of its date, again on 30 April. 30 April.
Obliged.
Mailer for payment to direction, clear direction for payment mailer. Granted time 20, more than 20 times.
Yes.
Lordship, can this matter be taken up sometime? Lordship, I don't have the proper instructions for this. That's why.
After some time.
Yeah, please, Lord.
Yes.
My lord, this application has been preferred, my lord, seeking some more time, my lord, to pass appropriate order under
We passed a similar matter yesterday.
Lordship, exactly similar.
All right. You'll be given 60 days
Lot
for further time. From the date of receipt of a certified copy. I disposed.
deeply obliged.
Lordship, before I don't want to waste anybody's time. Lordship, can this matter be taken out of some? There's some technical information which I think it will be best suited for being presented by Counsel B. Gugoi. He's on legs, Lord.
The instruction that I received from my friend was that they are willing to file an affidavit. So that was what was told to me. They file an affidavit.
But some information might be said by him that which is right.
After some.
Much blood.
Yes, APDCL. For APDCL. APDCL. Wait for some time. APDCL control.
They have
Some
in the
affidavit has been filed.
opposition file.
Filed.
It does not come in the record.
So you want to file a rejoinder?
Actually, nothing is there, my lord. I may file, I may not file also. Does it come on, my lord, after view vacation 24th, my lord?
24th.
Yes, my lord. My lord, it can be disposed of. Very small issue is involved.
All right. It's submitted by MSN Soikia and counsel to that affidavit has been filed by the respondent DMDA.
Respondent. GMD is James report.
DM, which however not connected to case report. We therefore submit the matter immediately after. Maybe listed again on 24th.
All right.
We have it on 24th April. On which date an attempt will be made to dispose of the.
All right.
Yes.
My lord, this is an application under section 11 for the appointment of arbitrator. And in this case, my lord, I invoke the arbitration clause at page 99, my lord. But there was no response from them, my lord.
We have not received such application. Perhaps it is that they withdraw all the arbitration proceeding by petition letter dated 12/11/2020, page 266. Perhaps we have answered 266 page. Notice of withdrawal of arbitration proceeding addressed to 266. To the general manager, construction, notice of withdrawal.
What is this?
My lord, I have explained in my reply. Affidavit in reply, page number 4, my lord. Page number 308, in continuation it is.
What have you explained?
And my lord, paragraph 10 is relevant. At page number 307, regarding the receipt and of the notice also, that the statements made in paragraph 11 by the respondent in their affidavit in opposition regarding non-receipt of the notice dated 29/11/2019, the deponent begs to state that the deponent denies each and every statement made by the respondent in this regard. The deponent further begs to state that the said notice dated 29/11/2019 was sent by petitioner to the respondent by registered post with acknowledgement due. And as for the acknowledgement receipt, the said notice was served upon the respondent number 2 on 6/12/2019 and on respondent number 3 on 6/12/2019 and on respondent number 5 also on 2/12/2019. But the respondents failed to act as required upon the arbitration procedure. Regarding the statement
But is
made by
this
the
letter withdrawn?
My
Did you
lord?
withdraw this letter?
That was, I have mentioned here.
No, mentioning is okay, but you said it is an error of judgment.
Yes, error of judgment.
But this letter was not withdrawn. You should have withdrawn this letter.
It is not withdrawn, but because of the financial dues, this was issued. But
it may be you can't be allowed to blow hot and cold.
But no
There's a
payment was.
clear indication that you don't want to press the arbitration.
Yes.
and then you say it is an error of judgment in your affidavit. There is no corresponding.
Some assurance was given during the COVID-19.
What it may be, whatever it may be, then you should have clarified or withdrawn this letter.
I have already fulfilled some claims. Here are the claims at
You have, you have not withdrawn this letter.
Yes, I did not.
You asked them to appoint an arbitrator, which according to you, they do not respond and you are before the court. And again, you issue a letter by which you are seeking to withdraw all your arbitration claim. In this you explain that it is an error of judgment. How is that possible?
That was only for the purpose of the releasing the legitimate dues, but no dues was released.
No, that even if we record it, then it is a good ground to dismiss your petition because you are using tactics which are not acceptable in the parameters of law. You are issuing a letter saying something which you don't mean so that your dues can be released. How is that possible? You think about how to, in the face of this letter, where is the demand? In the absence of a demand, where is their failure to appoint an arbitrator?
Yes, earlier demand was there.
Earlier, but in face of this letter,
I will take some instruction from
you do. Matter be posted after 4 weeks, enabling the complete petitioner obtain his instructions in terms of the communication dated 12/11/20 issued to the general manager and Railway, Maligaon. Within bracket page 266, the paper. Placed after 4 weeks. Mr. Dr. DC appears for the Railway. But
Your Lordship, in the last hearing, you told me to appoint an arbitrator, appoint an counsel for it.
Appoint a
counsel.
Amicus Curie was appointed.
we had appointed an amicus.
Yes, Lordship. D. Gogoi.
Yes, he was here for a while.
Before that, Your Lordship, I want some clarification.
No, let him come. We have already appointed him.
No. Your Lordship, if I am required to appoint an counsel, so Lordship, I request to go to the original petition, page number 14.
We have already appointed an amicus by this order.
Okay.
You wait for some time, let him come. Please inform him.
Okay.
He go going. He go.
Sir, may I pray for taking up this matter at 2 minutes? In this matter, the pleadings are completed. It may be fixed for hearing, Lordship. So can it be taken up 2 minutes? If I'm led by Mr. Kane Chaudhary, he is on legs in court number 1.
These matters are what? These are to be heard on admission hearing.
Admission hearing.
Why?
In fact, my lord, on the one repetition, the other two repetition, possibly your lordship may not have to go into the only first repetition, and it may not take much time, my lord. We can complete it in 15 minutes. But there's only one point which your lordship will like to address. Can it be at 2 minutes? I'll just time.
2 p.m.
If he's asking for that, I cannot directly object to it. 2
p.m.
Great to letter.
In this matter, I have been engaged only last night. I am given to understand, my lord, we are required to file a reply. The state has already filed its affidavit. The reply is almost ready. The lordship may give us a week's time. We'll file it and it may be taken up immediately on reopening. We have, otherwise I had a word with my learned friend.
On 29th of
on 29th, my lord. They have some urgency. So.
No, it might have been listed again on 29th April. April.
It's April.
April or May?
April. April.
29th of April. Meanwhile, petitioner is also permitted to file a reply. Reply. It's accordingly Mr. Rai Chaudhary, Senior Counsel, assisted by Mr. D. Dak for D or B?
T for Tamil Nadu.
D. Dak. For the petitioner, Mr. A. Sharma.
For respondent. I'm appearing for respondent number 326.
326, Mr. You are B. Dak. For respondent number
7.
Seven not referred.
Not
referred. Order already issued to
hard or appeals for what?
Interim.
So the only thing is that, if I may just object to that, on the last occasion, we had objected against the renewal of this interim order. We have filed an affidavit to indicate that the interim order that was obtained by suppression of certain facts. It was informed for the Honorable Court. No, Lordship. We had filed an affidavit and we had prayed before this Honorable Court not to extend the interim order. And the interim order was not extended on that.
There is no application for vacation.
That is true. That is true.
Interim order is very important. The next day.
But it was not extended on the last occasion for this particular region.
No, we said if any.
Yes, Lord.
Interpret.
Yes, Lord. Yes, Lord. Oblige, Lord.
Lordship, today I have filed affidavit in opposition in this matter, Lordship. It is not in record. May I pay to take up this matter after vacation along with this affidavit?
Yes, Your Lordship, but there is an interim order, Lordship, that may be.
All right, matter be listed again on 21st. 21st April. It is submitted by the council appearing for the respondent that an affidavit has been filed. Stop. The same, however, is not connected to the case record. No, affidavit is here. It is available here.
This is I, Lordship. I.
Huh?
Just now I have filed affidavit, Lordship.
IA.
I was disposed of, Lordship.
I have filed an affidavit. What affidavit have you filed?
Lordship, affidavit in opposition, Lordship, against the
Affidavit in
repetition.
opposition. You have filed it today.
Yes, Lordship.
Okay, it has been filed today.
In both the
As-
cases,
as-
Lordship.
As such, it says it's not available in the case record. As agreed to by the council for the parties, had to be listed again on 21st of April. The petitioner are permitted to file their reply.
Yes,
In the meantime, interim order passed earlier will continue with the next thing. Interim order in both the matters. Is there an interim order in both the matters?
Yes, Your Lordship. In 7.
21st of April.
Interim order only in 48. 48, item number 738.
My lord, a stay vacating petition was filed against the interim orders of this court. And a stay vacating petition number 7, I number 775, that has been dismissed, madam.
So is there an interim order in both the matters or only one matter?
No, only in 738.
Interim order in item number 48. We'll continue to the next thing.
What's up?
All right.
To implement respondent number 4.
Respondent 4. Why is it to be implemented? Why is the implement necessary?
Implement is necessary because 50% was paid by petitioner earlier from here only.
Yes, any objection? Right, third, I, the IA has been filed seeking implement of chairman come managing director. National Scheme Finance and Development Corporation. Only one. It is submitted that the seat of the party is required to be arrayed as the party respondent for effective for so that effective orders can be passed with the accompanying towards the claims made by the petition. That prayer made is not objected by the council appearing for the other respondent. That view of the matter, the I is then allowed. Chairman of the Director National Scheme Finance and Development Corporation. So, he arrayed as respondent number.
I have to respondent number 2.
Huh? Respondent 4. In WPC number 546. Amended post title filed by the petitioner in 2 weeks from copy of this order be retained in case report of the IA from this and the law response. In WPC 546, right, in view of the order passed today in IS group, so and so has been arrayed as respondent of 4. Petitioner will file amended post title within 2 weeks from today. So let notice issue of the newly pleaded respondent steps by registered post lady within 2 weeks from this recording.
May it please, Your Lordship. Lordship, with respect to this, we have implemented the Ministry of Jal Shakti as a party, Lordship. But there is some error in the address, Lordship. So,
correct it.
with the liberty to file a new one, Your Lordship.
You want to withdraw this
Yes,
and
Your
file a
Lordship.
new one?
Yes, Your
Right. Counsel
And-
for the petitioner takes liberty to withdraw the IA as certain inadvertent errors accepted and seeks liberty to file it fresh after making necessary prayer made to the
And Your Lordship,
IA accordingly.
uh, and there is further necessary to implement the Brahmaputra board also, Your Lordship.
Whatever you
As a
want to
part-
do it afresh.
Okay.
We are permitting you to withdraw.
Okay.
You file afresh.
Okay.
IA then
Obliged.
is permitted to be withdrawn and let's withdraw with liberty. Yes, if it
Yes,
is
my lord, we are awaiting up-to-date instructions, my lord. What had happened here, my lord? Petitioner is praying for setting aside of the bill as well as restoration of the electricity connection, my lord. My lord,
you get your instructions on Thursday.
yes, my lord.
Thursday? Please take it on Thursday.
Right.
It's, I think, 10. Enabling the static council appearing for a PDCA to complete this instruction.
Obliged.
Yes.
The last order, I think. Proceed payable.
So limitation.
Limitation.
But this will require some hearing.
My lord, this will require hearing. Now he has come with a different issue. The affidavit which has been filed by the central government has been, my lord, signed by some other authority, and he, according to him, my lord, he cannot sign that affidavit.
Actually, Lordship, the contract agreement was signed between CW Tejpur and CW, our party. And it was cancelled by CW Tenga, that is equal authority. And that was also without any notification to us, that will be decided in arbitration. Now, the additional affidavit filed by this Union of India is signed by a G, garrison engineer, who is not the party to it. And that's why I'm calling this page number 6 of 2A of Conciliation Act. That means it's a GH.
We take it up after reopening again on a date. It requires some hearing. We picked it on 29th of April.
Your Lordship, either it's 26th or otherwise after May, 1st May.
1st May. Then 8th of May.
8th
6th of May.
6th May.
6th of May. Okay.
We'll have it on 6th of May. Council that it will be listed again on 6th of May. As it had to require some hearing. Right.
All right. Otherwise, in this case, charge sheet submitted. So petitioner,
Where is the petitioner?
sometime before you call me.
He'll call up at 2 p.m.
At 2, okay.
At 2 p.m.
May I please interrupt? Lordship, leading counsel Mr. Artificer is on legs in another court. Can the matter be passed over for typing?
We will matter be listed after the vacation.
But Lordship, but they have not been paying the wages of the employees for last 2 years. That direction may be given. Last payment was made on 14th August.
Matter be listed after.
Like.
Yeah,
Lord, in item 45, my lord, I am appearing for the private respondent. 227.
Yes.
Lordship, my senior is in legs in court number 5.
Who's your senior?
PK Singh. Lordship, we also have to take instruction from the department. We also have to take instruction from the department.
After for the takes 2 weeks time to complete her instruction. Let's take a look. Then item number 45.
Item 46, my lord, same order may be passed. In item 46, I am the
Yes,
petitioner.
yes. 45, we are reporting it, but both are connected, so it will be listed together.
Oblig.
If I have instruction to withdraw, there are many methods. I want to withdraw 2942.
294.
No.
Yeah. You are appearing in this matter?
Yes, sir.
As the petition?
Yes, sir.
That.
Much.
It's reported that
Lots.
Mr. KL, the other matters would be listed
Yes,
separately.
Here, the proposal was though submitted, my lord, but it could not be forwarded to the finance department in the online portal because, my lord, there was a cut-off date. So there's some delay on our part on the PWD. Now, my lord, we are, my lord, re-appreciating the entire, my lord, process, and a fresh proposal will now be submitted. We pray for some further time, my lord. Within April, it will be submitted. Because it will have to come from the division again. Your earlier proposal has got lapsed. Sometime.
You're for the finance department.
No, PWD, my lord. All components of PWD.
Well, propagate part of right, it- right, right. They put it out, but it offered subject, right, but subject, subject. Steps are being taken.
My lord. It shortly we will do that, my
In the next 3
my lord.
Since the matter is, my lord, relating to land acquisition, my lord, up to date interest may be also calculated. Up to date interest, my
for that. First week of May.
My lord, let it be in the second week, my lord, on 9th or 13th, my lord. 13th or 14th of May.
14th of
My lord, around that.
Please don't do it.
Here, my lord, I have got the entire instruction. I will file it by, my lord, or by Friday. By 11th, I will file the affidavit.
In respect of private respondent lordship, he has a direction to the respondent to file
Now,
a.
we have already intimated him, my lord. Otherwise, from our side. So there is an order for taking registership as well as justice. From our side also, we have intimated because it relates to a tender process. He is a L1 bidder. No, only registered for three. But we will post it on 29th, my lord, before that possible. My lord, because it,
For which department?
health department, my lord. My lord.
Okay, interim may conflict. There is an interim order. Hello.
Wait, my lord, before my learned thing starts, my lord, these 3 matters can be taken after the holiday.
For admission,
Yes, my lord. Or, my lord, if it is exchanged, your lordship may admit it and fix for final hearing immediately after vacation, my lord.
No, let it remain in the same status.
I have no objection to that also.
after 2 weeks.
Your lordships kindly give a date here.
There is some interim order.
Yes.
No.
No. In fact, my lord, this matter was heard at length. Judgment was reserved and it was released. My lord, we are reopening on 21st. Lordships can have it on 28th or 29th, my lord. 29th is a Tuesday.
I don't know if whether it is bench
Or whenever your
for
lordship.
this bench, but 29th, as per the docket, there are several matters.
Okay. Then it can be on the first, my lord, 1st of May. 1st of May to Khula.
Yes, we can have it on first of.
Yes.
It's taken on first of.
Deep.
You said it was hard
Actually, it was heard before court number 1, my lord. Sorry, court number 4. Then it was released.
Released because of the fact, my lord, the client tried to approach the honorable judge. That is in the, my lord.
In fact, my lord, he was traveling by the approach করার নাই করিব চেষ্টা করি
চেষ্টা করেছে
that too after half dictation was
All right.
One has to be one
Let's not say anything unintentional.
Here in this case, Lordship, charge sheet submitted, Lordship.
Sheet up.
Right.
This is the second bill.
Second bill.
This is the second bill. So the earlier bill, like
There only one earlier other court. In this petition only one petition.
by 201 past 89 months. Submitted.
I see.
Charge number
49/25.
49/25.
Dated 29/3/25. 3/25.
Hello. If anti-safety bill, my lord, take it.